Today in this video we are going to see about the Code of Civil Procedure 1908, the introductory part. So we are going to see the meaning, extent, and then some of the definitions we are going to see in this video. The author of this Code of Civil Procedure is Sir Arthur Hobhouse during 1877, and with so many amendments and so many modifications, this has been enacted as Code of Civil Procedure during October, that is 21st March 1908, and it came to effect from 1/1/1909. So the actual effect of this act is 1/1/1909, and then we will see that is this is an act to consolidate and amend the laws relating to the civil procedure in court. Actually, how the civil cases are conducted in court and what are the procedures to be followed in proceeding the civil cases and to award degree, that we are going to see in this video, that is particularly the introductory part. And regarding the content of this Code of Civil Procedure, it contains 158 sections in 11 parts and 510 orders, 51 orders and 620 rules, and then 8 appendices and 2 to 23 forms. So to repeat again, 158 sections in 11 parts, 51 orders and 620 rules, and then 8 appendices and then 223 forms. This is the content of the Civil Procedure Code. And now we will see the preliminary. Regarding the preliminary, short title, commencement and extent. The short title is, this is called the Code of Civil Procedure, the laws relating to the civil procedure. And then actually the commencement is 1/1/1909. Actually it came into effect from 1st January 1909, though it was enacted during 21st March 1908. And then the extent, it extends the whole of India except Jammu and Kashmir and Nagaland and other tribal areas. Then now we will see the definitions of some of the important terms, that we will see one by one. First, code. Code means, civil procedure code means it includes rules. This is called, the Code of Civil Procedure is called Civil Procedure Code because it contains only the procedure to be followed, and unlike punishment given by the court in case of IPC, this purely defines the procedure to be followed in case of civil cases. It has established the rights and liabilities of a person, the litigant and opponent. Then now we will see what is code. It includes rules. Then second thing is a decree. Decree means formal expression of an adjudication. So the on the end of the adjudication, an order will be given, that is called decree, according to section 2, subsection 2. Then decree holder. The decree holder is the one who on whom the decree is ordered. That is called decree holder. Then district. Section 2 within 4, that is local limits of jurisdiction. Usually in civil cases, the lowest the court will be the will be the court for undertaking the cases. And then pleadings. Pleadings, the what are the plaint or written statement, the complaint given by the plaintiff, and the for that the reply is given by the defendant, that is called written statement. Both these things are included in pleadings. Pleading means it is a complaint by the plaintiff, and the reply by the defendant is called that is plaint, that is pleadings. Plaint means that is, so the plaintiff, the one who want to do justice for him, or the other party failed miserably in enforcing the rights of the plaintiff. The plaintiff institute a suit, or he makes a complaint to the court for the institution of the suit, that is called plaint. Plaint means the statement given by the plaintiff to the court for establishing his rights is known as the plaint. According to Order 7, it is otherwise called institution of suit. The suit is filed in the court by the plaintiff is known as the plaint, according to Order 7 of Court of Civil Procedure. And then the written statement, that is, the written statement is usually given by the defendant within 90 days from the filing of the case by the plaintiff. And then set off, according to Order 6, Rule 6, set off means whenever the money lending case and some problem in the settlement of money cases, and then already then agreement is there, a person or some other contract will also be there. Then if the defendant has to give, so totally if the plaintiff claims some 1 lakh rupees, and the defendant what he says, out of 1 lakh rupees to be owed to plaintiff, so the plaintiff has to give some 20,000 rupees to the defendant, and that is called set off. So the remaining 80,000 he accept means that is called set off. And then next thing is this is according to Order 6, Rule 6. Then counter claim, that is the from plaintiff side, that is the counter claim by according to Order 8, Rule 6A to 6G, the instead of plaintiff claiming, the defendant claims something from the plaintiff, that is called counter claim. So the plaintiff has to owe something to the defendant, that is called counter claim. Then interrogatories, that is the questions, the interrogatory means questions, is known as formal written questions. It is always called formal written questions, is known as interrogatories, that is according to Section 30, Order 11, Rule 16. This is called formal written questions. Then framing of issues. What is meant by issues means some issues will be there in any plaint. So that is called framing of issues. If one party affirms and another party denies, if there is no affirmation, no denial for the affirmation, that is A has to give some amount to the plaintiff claims some 1 lakh rupee from the defendant, and if it is accepted by the defendant, then there is no issue, framing of issue is not at all there. If he is if he is not affirming, he denies that I am not to pay some 1 lakh rupees to A. So this is, if the denial is there, then framing of issue will be there. Framing of issue will not arise when there is no denial for the affirmation by the plaintiff. Then framing issue. Then first hearing. The court will always try to find out the truth behind the claim and the counterclaim by the defendant. So this is called the first hearing, to find out the truth behind the case. Then affidavit. Affidavit means fact to be proved. Usually when the party has to prove himself that he is so and so, that is called affidavit. And sometimes the affidavit is given by the Commission of Oaths for any correction in date of birth or in marriage certificate and other things. The affidavit will be given by the Commission of Oaths, stating that this is the true position of the person who is asking for the affidavit. Affidavit means pramana patiram. So usually it is given by the Commission of Oaths. And first hearing, affidavit we are told, and adjournment. Whenever the case hearing is adjourned, that is mentioning without the other date, or postponing the hearing, then it is called adjournment. Then appearance and non-appearance. Then this is according to the Order 9, Rule 2. Whenever the court send the summon to defendant for appearance in court to depose the witness or depose the hearing, what all the court asks the witnesses and other things, then it is known as the appearance. And non-appearance will lead to sometimes the ex.parte order. So to avoid all those things, whenever the summon is issued, the parties have to appear before the court. Or if it is not possible to appear before the court by either by the plaintiff or defendant, on behalf of them, the lawyer can appear representing the plaintiff or defendant. Then ex.parte degree, Order 9, Rule 13. Ex.parte degree means whenever the parties, the defendant is not appearing for the hearing, for the whole hearing, then the ex.parte award will be given. That is, on behalf of plaintiff, the case will be ordered, and that is called ex.parte degree. Ex.parte order means the party is absent, that's why, because he has no say on the case, and what are the affirmation done by the plaintiff is true, because the defendant is not appearing to the court. That's called ex.parte degree. Examination of parties by the court. So to find out whether the affirmation done and affirmation are that is negating the affirmation or denial of affirmation will be heard by the court, and it will see the truth behind the case. So the parties will be examined by the court according to Order 10. Then admissions. Admissions, that is, the admissions may be oral or written. Whenever the parties accept the affirmation, then it clearly indicates that he admits the case, and no other denial will be there. That is called admissions. Then judgment. Judgment given by the statement given by the judge on the ground of decree or order. So the judgment is given on the basis of decree or order by the judge. Then decree. Decree means formal expression. After the judgment, the formal expression of the judgment is known as a decree. Decree means order. And then the order, so the order may be interim order, interlocutory order, injunction order. Order may be, it is not the final one. Even when the case is going on, the order will be given by the court. It may be stay order, it may be the interlocutory order. Then interim order, then whenever the court decides that interim order is required to postpone some of the happenings in the case, then it may give interim order. Then stay of suit. The stay of the trial is called the stay of suit according to section 10. Now we will see some of the, we have already told you some 158 sections are there, and 51 orders are there, 620 rules. The rules are usually made by the High Court, and 8 appendices and 223 forms. The out of 51 orders, 21 orders are very very important, that we will see one by one. The order number 1 is called parties to the suit. Who are all the parties? That is defendant and plaintiff. And then frame of suit. So the order 2 is called frame of suit. And order 3, recognizing agents and pleaders. And 4th one is institution of suit. And 5th one is issue of service and summons. And order 6, pleadings generally. Order 7, plaint. Order 8, written statement by the defendant as a reply to the plaintiff. And then the constitution of the appointment of parties is coming under order 9. Order 10, the parties by the court, that is the 10, according to order 10 is called examination of the parties by the court. And then order 11, discovery and inspection. Order 12, admissions. Order 13, protection and impounding return of documents. Order 14, settlement of issues. Order 15, disposal of suit at the first hearing itself. So if it is not fit for hearing, it is disposed of in the first hearing itself. And order 16, summoning and attendance of witness. So issue of summoning and the attendance of witnesses in court. Order 17, adjournments. Order 18, hearing of suit. Order 19, that is the expression of witnesses. And order 19, affidavits. And order 20, the judgment and degree. Order 21, execution of degree and orders. So these 21 orders are very very important in civil procedure code. தமிழிலே ஒரு மனிதனுக்கு ஏற்படுகின்ற உரிமைகளையும் நிலைநாட்ட இந்த சிவில் கேஸ் பயன்படுகிறது. கிரிமினல் கேஸிலே பனிஷ்மெண்ட் யூஸ்வலி தி அஃபென்ஸ் என்று சொல்வார்கள். அதிலே அந்த அஃபென்ஸை அதற்கு பனிஷ்மெண்ட் தரப்படுகிறது கிரிமினல் கேஸில். இங்கே தி அவார்டிங் ஆஃப் டிகிரி, தட் இஸ் காம்பன்சேஷன் ஆர் தட் இஸ் தி ரெஸ்டியூஷன் ஆஃப் ப்ராப்பர்ட்டி போன்றவைகள் இங்கே நடக்கிறது. இதில் தோற்றுவாய் என்ற நடைமுறையில் இது 1/1/1909 அமலுக்கு வந்து வருகிறது. இது இந்த சட்டமானது உரிமையில் வழக்கு விசாரணை சட்டம் எல்லா இடங்களுக்கும் பொருந்தும். ஜம்மு காஷ்மீரை தவிர்த்து நாகாலாந்து அஸ்ஸாம் போன்ற ஷெட்யூல்ட் ட்ரைபு ஏரியாக்களுக்கு பொருந்தாது. அடுத்ததாக இதிலே டெஃபனேஷன்ஸ் என்று விரிவாக்கம் சொற்பொருள் விளக்கங்கள் கொடுக்கின்றோம். அதிலே டிகிரி என்றால் என்ன, ஆர்டர், தீர்ப்பாணை பெறுநர், ஜுரிடிக்ஷன், அந்த கோர்ட்டுக்கு எந்த ஜுரிடிக்ஷன் இருக்கிறது என்பதை பற்றி தட் இஸ் டிஸ்ட்ரிக்ட் என்கின்றோம். ப்ளீடிங்ஸ் என்றால் வாதுரைகள். அதாவது பிளான்டிஃப் வாதி தருகின்ற வழக்கும் அதற்கு ரிப்ளை தருகின்ற டிஃபெண்டண்ட்டுக்கும் பேர் ப்ளீடிங் என்று பெயர். பிளைண்ட் என்றால் வாதியானவர் கோர்ட்டிலே வழக்கு தொடுகிறார், அதுக்கு பேர் பிளைண்ட் என்று பெயர். அதுக்கு வழக்குரை என்று பெயர். ரிட்டன் ஸ்டேட்மெண்ட் எதிர் வழக்குரை டிஃபெண்டன்டால் கொடுக்கப்படுகிறது. செட் ஆஃப் என்பது எதிர்கட்டு. அதாவது பிளான்டிஃப்க்கு வழக்கு தொடரும் பொழுது டிஃபெண்டண்டானவர் தனக்கு கொடுப்பதாக கிளைம் பண்ணுகின்ற பணத்தில் வாதி ஏற்கனவே இவ்வளோ ரூபாய் தர வேண்டும், எனவே மீதி பணத்தை தருகிறேன் என்பது செட் ஆஃப் என்பது. கவுண்டர் கிளைம் என்பது பிளைன்டிஃபும் டிஃபெண்டண்டிடம் கிளைம் பண்ணுவதற்கு பேர் கவுண்டர் கிளைம் என்ற பெயர், எதிர்கோரிக்கை. இன்ட்ராகேட்டரிஸ் என்பது விடுவினாக்கள், தட் இஸ் ரிட்டன் கொஸ்டின்ஸ், ஆல்ரெடி எழுதப்பட்ட கேள்விகளில் கேட்கின்றது, இன்ட்ராகேட்டரிஸ் என்ற பெயர். ஃப்ரேமிங் ஆஃப் இஷ்யூஸ் என்பது பிரச்சனைகளை வரைதல். ஃபர்ஸ்ட் ஹியரிங் முதல் விசாரணை, அஃபிடவிட் பிரமாண பத்திரம், அட்ஜர்ன்மெண்ட் தள்ளி வைத்தல். அடுத்ததாக முன்னிலை அப்பியரன்ஸ் அண்ட் நான் அப்பியரன்ஸ், முன்னிலையாலும் முன்னிலையாவதற்கால் ஏற்படும் விளைவுகள் என்ன. அடுத்தது எக்ஸ்.parte டிகிரி, ஒரு பார்ட்டி அப்பியர் ஆகவில்லை என்றால் எக்ஸ்.parte தீர்ப்பு கொடுக்கப்படுகிறது. அடுத்தது எக்ஸாமினேஷன் ஆஃப் விட்னஸ் பை த கோர்ட், அட்மிஷன்ஸ் ஏற்புரைகள், இந்த ஜட்ஜ்மெண்ட் தீர்ப்பு, டிகிரி கட்டளை, டிகிரி ஆணை தீர்ப்பாணை, ஆர்டர் கட்டளை, இன்ட்ரீம் ஆர்டர் இடைக்கால கட்டளை, ஸ்டே ஆஃப் சூட் நிறுத்தி வைத்தல் போன்றவைகளெல்லாம் இந்த டெஃபினேஷனில் இதனை தெரிந்து வைத்து கொண்டிருந்தால் இந்த சிவில் ப்ரொசீஜர் கோடை சுலபமாக நாம் தெரிந்து கொள்ள முடியும். ஸோ வித் திஸ் we conclude this video.